Hello and welcome, everyone. Thank you for joining us today. Thank you for spending your lunch hour with us to learn about the ins and outs of practicalities of doing bankruptcy law, filing a Chapter 7 bankruptcy. My name is Anthony Peirera. I am the managing attorney for Metro Volunteer Lawyers. MVL is the pro bono arm of the Denver Bar Association in association with the Broomfield Bar, the Arapahoe County Bar, Douglas Elbert Bar, and First JD Bar Association. And what we do is we offer pro bono opportunities to attorneys to try and give back to the community. And one of the areas of law that we do is bankruptcy law. Okay. This is a free CLE offered by MVL. So I do want to encourage you to donate to us. All right. I'm going to do some quick introductions of our presenters, and then I will hand the mic over and let them get going. So first, I'd like to introduce Judge Thomas McNamara. He is a U.S. bankruptcy judge for the District of Colorado. He's been since 2015. He's a graduate of Yale Law School. And prior to joining the judiciary, Judge McNamara was engaged in private practice with a large Colorado-based law firm for about 25 years. And as a bankruptcy judge, he's been a member of the American Law Institute, Judicial Advisory for the local Bankruptcy Rules Committee, member of the 10th Circuit Workplace Conduct Committee, member of the Colorado Judicial Coordinating Council, chair of the International Judicial Relations Committee, and I'm sure there's other accolades, but I'm trying to do quick introductions. Also presenting today is Matt Skeen, who is the managing attorney for the Federal Pro Se Clinic. He is a CU alum, and for 10 years, he worked in private practice for Skeen and Skeen, and he represented debtors, creditors for Chapter 7 trustees in bankruptcy litigation. So you're in good hands with those presenters, as well as with Mark Larson. He is now the program attorney for the Pro Se Bankruptcy Clinic. Additionally, he has a solo practice where he represents debtors, creditors, and trustees in bankruptcy proceedings. He received his law degree from Thomas M. Cooley Law School. And with all of those quick introductions, I'm going to pass the mic over actually to Judge McNamara for a quick introduction.
All right, well, welcome and good afternoon. My name is Tom McNamara, and I'm a United States bankruptcy judge for the District of Colorado. I want to thank the Metro Volunteer Lawyers, as well as the Colorado and Denver Bar Associations for arranging this presentation titled Dipping Your Toes into Bankruptcy. In a few moments, you'll hear from our principal speakers, Matt Skeen and Mark Larson. Both, as already has been mentioned, are highly accomplished lawyers with decades of experience in the bankruptcy field. And we're also lucky that they're leaders in the Federal Pro Se Bankruptcy Clinic, which is a partnership between the Colorado Bar Association and the United States Bankruptcy Court for the District of Colorado. Now, I want to start by taking just a few moments to introduce the topic for today's presentation. So I want to start by thanking you for taking the first step, spending the time to learn more about bankruptcy practice and what you can do to help individuals in need of legal assistance who may be considering bankruptcy. And I want to assure you that there really is a lot that you can do, even if you're not an expert in the area. My favorite quick summary of the essence of bankruptcy comes from the Supreme Court's 1991 decision in Grogan versus Garner. Writing for a unanimous Supreme Court, Justice Stevens recognized that bankruptcy provides a temporary safe haven for, quote, honest but unfortunate debtors who can reorder their affairs, make peace with their creditors, and enjoy a new opportunity in life with a clear field for future effort, unhampered by the presence or by the pressure and discouragement of pre-existing debt. And, when you think of it that way, bankruptcy really can be a lifesaver for those who need its protection. The foundation, the end goal of bankruptcy is the possibility of a discharge, which gives a fresh start. And the discharge is an economic second chance for debtors, but it also acts more broadly as a sort of safety valve for our economy. Now, underscoring the importance of bankruptcy in our democratic system In Article 1, Section 8 of the United States Constitution, it directs Congress to establish uniform laws on the subject of bankruptcies. Although we have had bankruptcy laws since the founding of our country, the modern bankruptcy system consists of a series of statutes enacted by Congress in 1978 and then amended periodically thereafter. And these laws are principally compiled in Title 11 of the United States Code, and we generally refer to those as the Bankruptcy Code. The Bankruptcy Code provides for 6 main case types. Chapter 7, which is a liquidation chapter for individuals and companies, and that is the chapter that we'll be focusing on. So, the focus today, of course, is on individual bankruptcies because that is where the need is. And as I just mentioned, there are 2 main types of individual bankruptcies. I'm just going to summarize them very briefly, but in general terms, in a Chapter 7 bankruptcy, a debtor files a petition which creates a bankruptcy estate consisting of all of the debtor's property, less properly claimed exemptions, usually under state law. And importantly, and as we're going to hear today, the debtor must make full disclosure of assets and liabilities when the debtor files the petition. And then a Chapter 7 trustee is appointed to administer the debtor's bankruptcy estate. The Chapter 7 trustee collects and liquidates the debtor's property, and then, if there is enough, makes distributions to creditors in the order set forth in the Bankruptcy Code. And in Chapter 7, the debtor typically receives a discharge early in the case. I want to contrast that very briefly with Chapter 13. This is also an individual bankruptcy chapter, and it affords debtors receiving regular income an opportunity to obtain some relief from their debts while retaining their property. But the quid pro quo for keeping property is a distribution plan, pursuant to which debtors must propose to pay their creditors out of future income, generally over a 3 to 5 year period. And then if the debtor makes all the payments under the plan, the Chapter 13 debtor may obtain a discharge. Why do debtors need bankruptcy protection? It's a good question, and the main reasons are fairly clear in the literature. Loss of employment, family changes, including divorce or death of a spouse, unexpected medical debt, student loan debt, mortgage foreclosures, and also financial mismanagement. In recent years, in our district, debtors have filed somewhere between 6,000 to 8,000 bankruptcy cases annually. The numbers vary depending on the state of the economy, and the vast majority of these cases are individual cases. There are about 5 times as many Chapter 7 liquidations filed in Colorado as Chapter 13 reorganizations. And again, we're going to be focusing here on providing assistance to individuals seeking bankruptcy under Chapter 7. This is an area where pro bono assistance to debtors really can make a difference. It can help. About 10% of Chapter 7 cases are initiated by debtors without any legal assistance. And as you might imagine, those cases are not nearly as successful as they could be for debtors, even with a modicum of legal assistance. So on behalf of the Bankruptcy Court, including the 3 other Colorado bankruptcy judges, I invite you to consider pro bono assistance in this area through the Metro Volunteer Lawyers. Your participation really can help debtors. And pro bono work, I think, as you all know, provides its own special rewards, knowing that you are using your professional skills to help someone else who cannot afford legal representation. Now, you'll learn a lot today, but do not be daunted. Again, you can do this. And I know that from personal experience because bankruptcy was not my main area of practice when I became a bankruptcy judge some years ago. Chapter 7 liquidations tend to be simpler and more routine than other types of bankruptcy, and there are numerous resources available to assist you should you want to help on a pro bono basis. Some of the resources include the Federal Pro Se Clinic, and there are also publications from the Federal Judicial Center and the like. So please dip your toes into bankruptcy. And for those that are even more adventurous, you are, of course, also welcome to dive right in too. We're always excited to welcome new lawyers to the Bankruptcy Court. So with that, and thanks from the entire Bankruptcy Court, I want to pass over to the baton to Matt Skeen.
Thank you, Judge. I appreciate those opening remarks. I'm very happy to be here, and I think what I'd like to do is just jump right into our presentation. So I'm going to share my screen and we can move through the slides. It's basically what the forms look like when they're submitted to the court. Most bankruptcy debtor practices do have some kind of case software, such as the Stretto case, that makes the filling out of these petition packets much simpler. Most of the pro se debtors that we help just go ahead and print out the packet and fill it out by hand. Here's my presentation. Dipping your toes into bankruptcy, a word of caution. Oftentimes it's dipping your toes into any kind of law can be difficult and sometimes a little bit uncomfortable. But again, we hope that if you were interested in volunteering with Metro Volunteers Lawyers to do some kind of bankruptcy practice, we would be more than happy to help and answer any questions as questions arose. This right here is the document checklist. This is provided by the court, and it basically tells you everything that you need to submit to file a complete Chapter 7 case. It's a long list, and all of these forms are in the packet that I provided, with the exception of the certificate of credit counseling and of course, the photo or copy of the driver's license or other government issued ID. We'll talk a little bit more about the certificate. One of the requirements for a Chapter 7 debtor to file a Chapter 7 case is that he take an online or on the telephone credit counseling class, which they are generally cost about $20 and can be completed in about 40 minutes. And that's one of the requirements for filing. Another requirement is to provide, if the debtor has them, a collection of pay stubs, or also called pay advices. I believe between 2 and 6 months of those pay stubs if they have them. And then if they don't, there is another form listed on here, which is the local form basically stating why you don't have those pay advices. But this is the list, and we're going to go ahead and get a little bit deeper into each one of these requirements.
Now, there was what the asterisks mean.
Those are, so the certificate of credit counseling, and the other asterisk I see is the statement about your social security numbers. I think that those are filed separately, whereas if you file a petition, you can file one giant PDF, but these particular requirements need to get filed separately because the statement about the social security numbers is redacted and just held by the court for their information and not a public document. So the basic form that's filed is the voluntary petition. A lot of times pro se debtors make the mistake of just filing the voluntary petition without all of the rest of the required case portions. And what happens then is the court will issue something called a deficiency notice. And that will give the debtor 14 days to cure by filing all of the rest of the required documentation. And a lot of times, if the debtor has just filed the voluntary petition and has not prepared any of the other paperwork, when they get that notice, they're suddenly scrambling. And a lot of times that is when they call Mark Larson over at the Pro Se Bankruptcy Clinic for emergency assistance. The voluntary petition asks a lot of questions. One is regards to venue. The bankruptcy code is a federal code, but each district within the state has their own venue, and you have to file in the district in which you have lived the longest portion of 180 days. That's the 180-day rule. Now, there are some exceptions. If the majority of your assets are located in a different district than the district where you've lived for the longest portion of 181 days, then sometimes there's a little bit of flexibility in regards to venue, but generally it's where your residence is. One of the things you have to do to file is to pay the filing fee, which right now is $338. Sometimes pro se parties request that the filing fee be waived. There is a fee waiver application that can be filed with the court. And if that's not granted, the fee can also be paid in installments. The voluntary petition also asks about prior bankruptcies. You're only allowed to get a discharge once every 8 years. And so one of the things that we talk to clients about is to whether now is the time to file, or because if you fall back into debt immediately after filing a Chapter 7 case and getting your discharge, you're not eligible for another discharge for 8 years. And so it's not something to do lightly. You want to make sure that this is going to take care of your debt problems. A lot of people come to the clinic in a panic because they're about to be evicted, and they think that a bankruptcy will stop the eviction. And it will, but there are a lot of requirements for the automatic stay to be enforceable against the landlord. And one of them is that you deposit 1 month's rent with the court in order for the stay to be operative. And a lot of pro se debtors don't realize this, and they just think that by filing an emergency petition that'll stop an eviction. And it may delay things for a little while, but unless you really follow the rules about evictions, it's not going to be much more than a very temporary solution. One other thing about the voluntary petition is, and you'll see at the back of the materials, there are some required disclosures that lawyers are supposed to give to their clients that essentially explain the difference between Chapter 7 and Chapter 13 bankruptcy, and some other information about bankruptcy that you're, as an attorney, would be required to give to the client to fulfill your duties under the code. This here is the SOFA. What we fondly refer to as the SOFA is the Statement of Financial Affairs. So the Statement of Financial Affairs, it has a lot of questions for the debtor, including past addresses. They have to list their last 3 years of income. So the last year, the year before, and this year to date. And that is broken down into 2 areas. There's income for wages and from businesses, and then there's other income, which could include gifts or alimony or Social Security payments or other benefits. A lot of the questions in the Statement of Financial Affairs have to do with any questions about any kinds of transfers of money or assets. And the reason for that is they don't want you to just give all your stuff away to your friends or family before you file bankruptcy, because the non-exempt assets that you own are intended to be used in a liquidation to pay creditors. And so they look for any uncharacteristic transfers. Another reason they look for transfers is for the purpose of looking for preferences. The idea behind preferences is that if you owe a lot of people money, and one of the people you owe money to, maybe your friend or related to you, maybe you borrowed $5,000 from your father, and you would rather pay him back before filing, but you wouldn't want to pay back all of your other creditors, and that's considered a preference. And so there's a 1-year look back on debt payments to insiders, such as family or friends or people you do business with, and a 90-day look back period on other creditors. And so if it appears that you have chosen a preferential creditor that you want to pay back right before filing bankruptcy, sometimes those payments can be clawed back into the bankruptcy estate and used to pay creditors. And the last thing that your client wants to do is to call their mother and say, "Hey, Mom, you remember that $5,000 I paid you back a couple months ago? Well, you're going to have to come up with it again to hand over to the trustee."
Matt, if I can interject just briefly.
Yes, Mark, please do.
The SOFA it's a long document. It has a lot of questions. Not every question is going to apply to every debtor. It's a one-size-fit-all document, but be careful to include everything that you possibly can, because you do not want to run afoul of the bankruptcy code and even bankruptcy fraud. But it's not unusual to say not applicable or no on a lot of those questions in the SOFA. So don't get overwhelmed by how many questions there are.
Now, one thing I should probably add as far as context is, who are you filling out these paperwork for? Who's going to be looking at it? When a Chapter 7 case is filed, a Chapter 7 trustee is appointed to administer the case. And about 30 days after the petition is filed, the debtor will have to appear at something called a 341 meeting of creditors. And at that meeting, the trustee will have gone over the documents filed with the court and will have a lot of general questions for the debtor, but a lot of specific questions for the debtor related to their schedules. And it's the trustee who makes the determination as to whether there are going to be assets that can be liquidated on behalf of creditors, or whether this is going to be filed as a no asset case. And at which time he issues something called a notice of no distribution to the creditors, which essentially says you're not getting anything from this debtor. And that goes out before a discharge enters and lets the creditors know that there's no reason to file a claim in the case. Alternatively, if the trustee does find assets, he'll send out a notice of possible distributions and instruct creditors to file claims while the trustee liquidates whatever assets there are to pay those creditors pro rata at the end of the case. There's a page in there called the Summary of Assets and Liabilities. And this page, for some reason, comes before all of the schedules A through H, I, J, A through J. And it's a silly place to put it. It should really come behind those schedules, because the answers to the summary of assets and liabilities lie in the schedules. And I've had a lot of pro se debtors say, well, I don't know how to fill out this form. And the answer is to wait until you fill out all the other forms. And then if you look on the summary, it asks you to refer to different lines on the different forms to come in and fill the summary. So my piece of advice on the summary is to do that last. So beyond that, we have our schedules. And the first set of schedules is the Schedule AB, which has to do with property. This is the part of the bankruptcy.
There was a chat question, I think, that had to do with the assets and liabilities, and now it's gone away, but I think, just to summarize what I recall, it said that what if the debtor has a judgment where the debtor was the prevailing party on the judgment, the plaintiff, but the amount had not been paid. And so that's a fair point. In that context, I would submit that the judgment would be listed as an asset of the bankruptcy estate on the schedules. The dollar amount can appear there. It may or may not be collectible. And that might be something that a Chapter 7 trustee might want to examine and try to collect if there was a judgment in favor of the debtor that the debtor had not been able to collect before the bankruptcy. So I hope that answers that chat question.
Yes, I would concur that that would be listed as an asset.
And
so
maybe
here's-
exemption,
yes, perhaps.
perhaps.
Yeah. So there are a lot of client questions about listing property. A client may ask, well, what if I don't have anything? You have to list something, because if you don't list anything, then the trustee, when you show up for your meeting of creditors, will take a look at your debtor and will say, Mr. Debtor, I see that you are wearing clothes today and you didn't list any clothes on your Schedule AB. What else didn't you list on your Schedule AB? And so everybody has some stuff. Generally, people have clothes, and generally people have a cell phone and sometimes a way to get around. And those are the types of things that need to be listed on their list of property. Do I need to count all my socks? No, you don't have to be that specific, but you have to be, the more specific you are, the more confidence a Chapter 7 trustee will have that you have taken the time and consideration to fill out your schedules correctly and completely. So while I would not list the number of socks that they own, I would list clothing, and I would describe the clothing as basic wearing apparel, including shirts, socks, jackets, shoes, hats, etc. How much should I value my stuff at? Generally, my advice is garage sale value. What could you get if you were going to try to resell your stuff at a garage sale or on Craigslist? Sometimes that gets a little bit more complicated when it comes to, say, house. House is generally, there's some more in-depth considerations that go into that kind of valuation. But Zillow would certainly be a good starting point if somebody owned a house. Generally, the tax assessor's value are considered to be undervalued for purposes of bankruptcy. But as a general rule for personal property, a garage sale value. Will I lose all my stuff? No. Most of the stuff that debtors have is exempt. And we're going to cover exemptions coming right up in Schedule C. And I'll explain what that means. But no, generally, most of the stuff that people own will not be lost in a Chapter 7 bankruptcy. What if I forget to list something? Try not to do that. But if you do, and if it comes out, or if you decide that if you suddenly remember it, what you can do is you can file an amendment and amend your schedules. But filing an amendment is not the easiest thing in the world. You have to send out a notice of the amendment, and you have to send out the actual amended schedules, and those go out to all the creditors, and it's really kind of a pain. So it's better if you don't forget to list stuff. What if I'm still paying on my car? Well, there's a place on the Schedule A, B for vehicles. And actually, if you're still paying on a car, your car is going to get listed in several places throughout the schedules. You'll list the car in your Schedule A, B, and then you'll list the debt to the car lender on your Schedule D as a secured debt. And then you'll probably list the car as exempt on your Schedule C. And then you'll have to decide what you're going to do with the car. And that goes on your statement of intent, where you can either choose to keep paying on the car, or give the car back to the lender and walk away from the loan. Or there's something called redemption, where if you have enough money to just pay the lender for the value of the car, you can file a motion to do that with the bankruptcy court.
That's where the software is really helpful. You
Yes.
type that vehicle in there one time, and it will populate to the different schedules as necessary, and the creditors as well. So it's one thing where I see with pro se debtors who come in and they're like, well, I already listed my car somewhere over, in the sofa or something. Well, yeah, you need to list it again. It's property. Yes, is exempt, and all. Yes, they're a creditor, so they're going to go on Schedule E as well. So the software is very nice in that respect.
Agreed. And then I believe on the sofa, there is a place to list property held for another person. So if you're driving your mom's car, which sometimes happen, it's not your car. You don't have a legal interest in the car. You have an equitable interest in the car. Life is complicated, and sometimes it's not the easiest to describe what's going on in the schedules, but you should do your best. And if the trustee has questions about it, they'll ask. So Schedule C, I guess before I move on to Schedule C, the last thing I want to say about property is that sometimes people, physical stuff that you own is fairly straightforward, but you really have to think about all of the stuff that you have. So bank accounts need to be listed, investment accounts, retirement accounts, claims. As the question that Judge McNamara addressed, if you have claims, they need to be listed as an asset. And if you don't list the claim and then try to bring that claim later after filing bankruptcy, one of the defenses to those claims is, hey, they filed a bankruptcy petition under oath that said that they didn't have any claims against us. And then, that just really complicates any attempt to pursue those claims, which are property of the bankruptcy estate, and the trustee is the only person was standing to bring them at that point.
Any ATV that you might have, you really do list everything as in that property, and hopefully most of it has an exemption. A lot of it does, some of it doesn't, but you need to list all of that stuff, even if you have a poor set of golf clubs like I have. You need to list it anyway.
So exemptions. I explain exemptions in the following way. A debtor may ask, well, I have clothes. Is the trustee going to take my clothes? And the answer is no. Trustee is not going to take your clothes. First of all, because your used clothes aren't worth that much. Trustee wants nothing to do with that. And the government, the state, our state and every state, has determined that there is a certain amount of property that everyone should be allowed in order to live with dignity. And that creditors, and by extension, your bankruptcy trustee, cannot take that away from you to satisfy your debts. And one of those things is clothes. So creditors cannot come and leave you lying naked on the street because you have a $2,000 clothes exemption. Most of those exemptions are found in the Colorado statute book under 13-54-102. And 13-54-102 has a very long list of all of the things that the state believes that a debtor doesn't have to lose in a Chapter 7 bankruptcy. Now, if you have property that exceeds the exemption amount, for example, if you had a closet full of fur coats worth $10,000, then you would have to turn over those fur coats to the trustee to try to sell to pay your creditors. But most of, at least the people who come to the Pro Se clinic, don't have a closet full of fur coats. Other exemptions include jewelry up to $2,500, household goods, $6,000, tools of the trade, unlimited exemption for retirement accounts. Sometimes debtors make a big mistake by emptying out their 401k to try to pay off their debt, and then it's empty when they come to see you, and then you have to tell them, well, you shouldn't have done that because you would have kept that retirement money. Personal injury awards, 80% of wages, cash in a bank account, guns. There didn't used to be an exemption for firearms. That's a fairly recent addition to the exemption statute. The legislature passed that in 2022.
And Matt, these are state exemptions, to be clear.
These are state exemptions. Yes.
Yeah, they're not the federal exemptions.
The bankruptcy code allows states to use state exemptions, so that's what Colorado has done. I know there was a chat question just a moment ago about all these exemptions, Matt, that you're discussing, and where are they? But I do think the slide does tell us that the other exemptions, the third bullet point, 13-54-102, I believe that's the law that contains a laundry list of all of the, or most all of the exemptions that you have down below. Is that right, Matt?
That's correct.
And then there are some other exemptions that are spread out in different other places. The main one also is identified there on the slide with the homestead exemption, which used to be much lower until fairly recently.
$75,000.
And now it's at $250,000 for starters, and it can depend also on your age and whether you're disabled and such, but that's a huge exemption.
And that's just for equity, equity that the debtor has beyond the mortgage. And so when it was $75,000, it was very difficult for anyone who had a home in Colorado for any amount of time to file with less than $75,000 of equity in their house. And this has made a big difference since it was passed in 2022. Burial plots, you'll get an unlimited exemption in burial plots. I have to tell the story of when my mother, who was a Chapter 7 trustee, had a debtor who attempted to claim his boat as a burial plot. He claimed that he wanted a Viking funeral. My mother objected to the claim of exemption and won. So nice try. But there is some room for creativity. Okay, Schedules D, E, and F, we've got creditors. There's our creditor, Snidely Whiplash. These are broken down between secured creditors, priority unsecured creditors, and general unsecured creditors. A secured creditor is a creditor with a security interest. That's usually your mortgage, who has an interest in your house, your car lender, who holds collateral in your car. Sometimes people buy furniture on credit, and that furniture may be covered by a security agreement. So secured creditors are creditors that have a interest in that basically have collateral on their loans, whereby if the debtor defaults, they can go after their collateral. And if you're a creditor, that's a good position to be in. Priority unsecured creditors are creditors without a security agreement, but have some other priority set forth in the bankruptcy code. The number one priority creditor is the IRS, Some also, if a debtor has a DSO, so a domestic support obligation, those are also given priority. So arrearages and child support, that would also be a priority claim. And those are the two main priority creditors, I believe. Maybe the government. Can you think of any more, Mark?
Colorado Department of Revenue, IRS, you've got the big ones, yeah.
Yeah.
It looks like there's quite a lot of interest here on the chat on exemptions and such. Maybe three or
Sure.
four questions we might want to take a quick look there. The first question, what happens if someone fails to list an exemption as an asset, like a pending personal injury case? I can maybe start with that one, and you can correct me if I'm wrong on that, Matt or Mark, and then hit some of the other ones. But the pending personal injury case, that would be listed as an asset. So it should be listed there as an asset on Schedule AB, and there's a line item for lawsuits. And then there's a potential for a claim of exemption. And as Matt explained, that should be claimed as exempt on Schedule C. Now, this question might suggest what happens if you fail to list it as an asset. Well, if you fail to list it as an asset, that can be a big problem. And we see this with some frequency, especially in like class action products liability cases. Vaginal mesh cases is one that we see quite a lot, where people may have forgotten that they list that as an asset, and to also claim it as an exempt asset, at least in part. And so what happens in those kinds of circumstances, if there's a significant amount at issue, the debtor may attempt to later amend the schedules to list the asset, and may amend to include the exemption. And they may also try to do that even after the bankruptcy case is closed, which can create some issues. But that's at least an answer to that first question. And Matt and Mark, if you want to weigh in or look at some of the other questions.
I believe there is an argument that if you don't claim the exemption, that the exemption can be considered waived.
Yes.
Which can be problematic. Also, if you don't list an asset and then the trustee discovers that asset, I believe there's case law that says that you can't then go back and claim an exemption in an asset that was either intentionally or unintentionally omitted from your schedules.
I think those are all concerns. There's even a concern if you fail to list it as an asset, but then it gets discovered later that your discharge might be revoked as well. So, I mean, the bottom line is you want to be very careful to include all of the assets, including personal injury claims, and to assert the exemption, because otherwise you're going to be subject to, you might try to amend it later, but you may not be able to be successful in doing that.
Yeah, you really do have to open yourself up, everything about your life in a Chapter 7. And debtors oftentimes don't think they can hold something back. I was in a car accident, 6 months ago, but that's different, and it's not. It may be a property of the state that needs to be disclosed, and you want to make sure that you're completely forthright with the court and the trustee for administration of your case.
Err on the side of disclosure.
Always. There's one question that says, is there a cap on the value of a bankruptcy Chapter 7? No. Corporations file Chapter 7 sometimes. It wasn't Bernie Madoff, was that a Chapter 7? And that was in billions of dollars. I know there was a trustee. I just don't remember if it was actually a Chapter 7, but there is no limitation on a Chapter 7 unless I'm missing something. I think there's no limitation.
Additional creditors, sometimes people ask, what if it's been turned over to collections? Do you list the original creditor and the collections agency? Yes, you do. There's actually a separate portion of your schedule for additional creditors. And general unsecured are what most people owe money to, as far as just credit cards and that payday loans, that kind of debt.
There's a question about, I'll just respond quickly to a question about internal conflict in the trustee's role. I mean, that's an interesting and difficult question. I think the theory is that the trustee who is paid, if they're paid, the amount is very low, they get $60 per case. And then they get a recovery based on the amount that's distributed to creditors. There's kind of a formula set up in the bankruptcy code. But I would say in a lot of cases, the Chapter 7 trustees don't get much, if anything, more than the $60. But their interests are supposed to be aligned with trying to collect assets for the benefit of creditors by, for example, pursuing assets that were not disclosed or pursuing claims that the debtors had. And so the general theory is that their interests are aligned. This question here suggests that maybe Chapter 7 trustees might not challenge the legitimacy of creditor claims. I suppose that's possible. They're supposed to evaluate creditor claims. And then if they don't, the debtors can also, and it's not typical, but they can also object to claims as well. But Matt, I don't know if you want to weigh in on any of that.
Well, we're getting kind of short on time, so I think
Okay.
I'm going to charge ahead.
Great.
So there is a place to list executory contracts and unexpired leases. I don't want to spend a lot of time on this, but I did want to just point out the issue of reaffirmation agreements. A lot of times debtors are worried. They say, well, if I file bankruptcy, am I going to lose my car? And I kind of mentioned this earlier, but one of your options with your car is to reaffirm the debt. And to reaffirm the debt, you enter into a reaffirmation agreement with your lender that essentially says the debtor gets to keep the car as long as they keep making the payments. I believe the debtor has to be current before most lenders will enter into a reaffirmation agreement. But if they're current and they're making the payments, that shouldn't be a problem to keep their car. And then I do believe that reaffirmation agreements have to be approved by the court. And the court makes a determination as to whether it's in the best interest of the debtor to enter into that agreement. I guess re-enter into the agreement. Co-debtors, the main thing to remember is that if you file bankruptcy, the other person who guaranteed your loan, your discharge does not apply to them. And so if you have co-debtors, they're still on the hook unless they file their own bankruptcy. There are a lot of questions about income and expenses in Chapter 7, and income and expenses are a lot of times more important in Chapter 13 when you're trying to get a plan confirmed and you're trying to figure out how much a debtor can pay into a Chapter 13 plan. But it is important in Chapter 7 as well. And one major place where it is important is and so in order to be eligible to file Chapter 7, as opposed to being forced into a Chapter 13, if you want to, forced is a bad word, but prohibited from filing Chapter 7 is your income. So, and it's done by household size. So in Colorado, a one-person household, if they make less than $74,274, they can file Chapter 7 without the presumption of abuse arising. If they are over $74,274, then they have to do a secondary analysis, which is called the means test. And the means test is a very long, complicated form that involves a lot of looking up various IRS thresholds, and it's kind of a pain to fill out. But luckily, if you were doing a volunteer case for Metro Volunteer Lawyers, the person you would be doing it for, income would necessarily have to be below this. And so any kind of pro bono work you did for us would be for people making less than this threshold amount. When you're filling out expenses, be realistic. Some people put $200 a month for food. I don't think anyone, at least with a family, spends $200 a month on food. I think it's a lot higher. A lot of people underestimate how much they spend on stuff. And then just briefly, I want to talk about what happens after filing. Like I said, a Chapter 7, a trustee is appointed. You'll go to a 341 meeting of creditors. They're all done on Zoom these days. Those are usually scheduled about 30 days after you file. You'll have to submit some additional documents to the trustee before the meeting, which includes the last filed tax return of the debtor and a bank statement. The trustee is looking for a story that makes sense. They want to look through your schedules, and they want to know that they want to be able to look at it and say, yeah, I've seen this before, and this makes sense. And if they have holes or gaps or questions where they don't understand what happened, that's where they kind of start to dig, and where you might get some more probing at your 341 meeting of creditors. A trustee generally on their docket has 4 meetings scheduled every half hour. So the average amount of time for a meeting for a debtor is going to be less than 10 minutes. So you're not looking at a full-on deposition for most cases. If the trustee has serious questions about what happened to people's assets, they may reschedule the hearing so that they can figure out what's going on. There's a 60-day deadline after the meeting to file an objection to discharge or dischargeability. Generally, creditors don't show up at the meeting of creditors. The main creditors you have to look out for are what we refer to as the X factor. So that would be ex-wives, ex-husbands, ex-business partners, ex-friends, and they're going to come and cause trouble. And so that's something to be aware of. Filing bankruptcy in the middle of the divorce can sometimes lead to a much more complicated bankruptcy. And these are the people who know about the storage unit down in Pueblo or wherever. And we're coming right up on 1 o'clock. And so I don't want to keep you too much longer. I am supposed to put in another plug for Best Case by Stretto. And the reason is that MVL has been given a grant through the American College of Bankruptcy to provide this bankruptcy software for people doing pro bono cases for MVL or CBA. So if you are looking to try bankruptcy and would like to be able to help someone and at the same time get a feeling for what it's like and take a look at the software and see if it's something you are interested in, I think this is a great opportunity. And
As is the clinic.
Yes, as is the clinic. Mark and I both run clinics. I do a federal civil litigation clinic, and Mark does the federal bankruptcy clinic, where we help parties without lawyers navigate the system. And we need volunteers. And if you want to volunteer, here's some contact information for people you can call. And we would love to hear from you. And both Mark and I are eager to talk to anybody and just tell them how the clinic works. And the one of the cool things about our clinics is that it's a minute of an hour of time. The opportunity to take on a full bankruptcy case, but then there's also opportunities to just talk to people about a discrete legal question. And it's very
Dip your
rewarding
toes.
work, and people are really appreciate it.
No. Literally dip your toes when you're in the clinic in reviewing schedules and answering questions for pro ses who are trying to get through the bankruptcy system. So it's a wonderful way to at least come in and get some experience and get an understanding and a feel for how bankruptcy works.
And I'm happy to stay on for additional questions, but we've reached the 1 o'clock hour. So if anybody needs to get going, I think that's fine. But if anyone would like to stay on for a little while and ask questions, I'd be more than happy to.
I just want to say before we start answering some questions, thank you to Judge McNamara, thank you, Matt, and thank you, Mark, for all your time today. We really appreciate that and educating us all about how we dip our toes into bankruptcy. So
thank you, everybody. I do have one question though on the eviction issue with the $100 deposit at to put a stay on it. Is that paid to the county court that's doing the eviction or to the bankruptcy court?
Well,
The deposit.
I believe it's the next month's rent. And so it has to cover the 30 days. So it's not $100, it's the whole amount of the rent. And that's deposited with the bankruptcy court when the Chapter 7 petition is filed.
Okay, my mistake. Yeah, it is $100. It is the rent, not $100. I wish my rent was that cheap. I appreciate that.
Sure.
A couple more questions from the chat that I don't know got answered. If you wouldn't mind just answering these real quick, is there a requirement or application to the bankruptcy court in Colorado in addition to being admitted to the federal district court of Colorado? Are they separate or?
It sounds like a good question for the clerk's
What was the
office.
question?
Yeah.
Is it if you're admitted to the United States District Court for the District of Colorado, you are automatically admitted to practice in bankruptcy court for the District of Colorado. So there's no extra step to become admitted in the bankruptcy court.
That's correct. And
But-
we don't have admission just for the case, special admission or anything like that. And you do need to be admitted in the United States District Court for the District of Colorado. We don't have a separate registry. We just look over there.
And it's pretty easy.
That's in addition to your Colorado license.
That is true. We're talking about the United States District Court for the District of Colorado, the federal court. You do need to be admitted to that court. But that's not a very difficult process. I think there's a short application, and I don't know what the fee is now, but it's like 150 or 200 or something like that.
Must have gone up 20 years ago. It was $50 I got paid, but a very easy process.
It has gone up, and I should just note that one of the uses for the fees is that the district court is using some of the monies to help fund and to some of these clinics and such in cooperation with the Colorado Bar Association. So some of that money goes to that.
Awesome. One of the things when we were talking about exemptions and things is, do you list your child's belongings as your property?
Mark says yes, I say no.
I mean, I list everything. I guess representing trustees, they're not going to say, I don't see any children's clothes listed here, are your children running around in the buff? No. But you simply say, we have clothes. You can even say baby clothes. We have baby toys, that sort of thing. I think that's all property that you own. I guess that's a good question. Do children own their own clothes? Are they separate and distinct? I don't think so. I don't get that involved, I guess, in listing the clothing for the children, but I certainly wouldn't shy away from it either.
You may have missed my question. I asked whether or not when you put exempt wages in a bank account, do they lose their exempt wage exemption?
Well, before they added an exemption for cash in a bank account, it was very important to claim the exemption in wages on the money that you had in the bank. And so I would always claim 80% of whatever money that was in the bank if that really did come from paychecks. One of the things that is always kind of can be concerning is you just want to make sure that you can show that that's all wages and it's not commingled. With the homestead exemption, the homestead exemption extends to proceeds of the sale of a house if they are contained in its separate in a separate bank account, and those funds are not commingled. And so I would say that yes, the money retains its character as wages as long as it's not commingled.
How about income from a trust set up for retirement, like a retirement account trust set up? Is that income considered exempt?
I mean,
if it's retirement funds and it falls under ERISA, the Employee Retirement Income Security Act, which is a federal act, or even the state act, I think it would probably be exempt. You can run into some trusts that are somewhat more problematic, and I wouldn't want to give a blanket statement as to whether or not they're exempt or not. It really kind of depends. We run into a lot of 529 accounts in bankruptcy where people are funding them for their children's education. Sometimes they try to deposit $15,000, $20,000 right before bankruptcy. And that has not been litigated, at least as far as I've seen, whether or not you can sort of do that to ride it through. But you do see some of these different accounts that may or may not be exempt.
That was the next question I have. And then the only other question I see in the chat is, what about designer clothing as far as your list?
well, I mean, if it's collectible, if you've got a giant Nike collection that's worth beyond the $2,000 clothing exemption, then yeah, I would say it's fair game.
Yeah, I understand there are some bags that are really sought after and expensive. I don't know about that sort of thing, but I've heard tell those would not fall within, most likely would be, exceed that $2,000 limit. So you could have to turn that over and have it auctioned off somewhere, theoretically.
Well, that is all the questions I've marked down from the chat. Thank you again so much for your time today. I really appreciate it, and I know the participants really appreciate it as well. So thank you, Judge McNamara. Thank you, Matt. Thank you, Mark. I appreciate you guys a lot.
Thank you.
Thanks,
Take care.
Anthony.
Thank you, everyone.
Hold on.